You've probably heard that $800,000 can get you a U.S. green card. But here's what nobody tells you: that money can disappear, and you still won't get residency. The EB-5 visa is real. It works. But only if you understand three things before you invest. I'm going to break them down right now. Stay with me. What is the EB-5 visa? The EB-5 investor visa is an official United States immigration pathway that enables foreign nationals to apply for permanent residency by making a qualifying investment in the American economy. The foundational premise of the program is straightforward. An investor commits capital to a business enterprise that generates employment for American workers, and in exchange, that investor, along with their immediate family, becomes eligible to pursue a green card. Established by the United States Congress in 1990, the EB-5 program was designed specifically to stimulate economic growth and job creation through foreign capital. It remains one of the only immigration pathways in the United States that does not require employer sponsorship, a job offer, or specialized professional credentials. However, as with any program of this magnitude, strict conditions and regulatory requirements are firmly attached. The investment thresholds. One of the most commonly misunderstood aspects of the EB-5 program is the investment amount. There are two distinct financial thresholds, and understanding the difference between them is essential before making any decisions. The first threshold is $800,000. This lower amount applies specifically to investments made in what are designated as targeted employment areas, commonly referred to as TEAs. These are defined as either rural geographic locations or urban areas experiencing elevated unemployment rates. The United States government established this reduced threshold deliberately to incentivize foreign capital into economically underserved regions. The second threshold is $1,050,000. This higher amount applies to all investments made outside of designated targeted employment areas. Your specific investment location will determine which threshold applies to your situation. Your money is at risk. This is the critical detail that far too many prospective applicants overlook, and it is the point that separates informed investors from those who make costly mistakes. The capital you commit under the EB-5 program is not a government fee. It is not a donation. And it carries absolutely no guarantee of return. Under the regulatory requirements of the program, your investment must be placed genuinely at risk within a qualifying commercial enterprise. This means you are functioning as a real investor in a real business project. And like every investment in any market, that project can either succeed or fail. If the underlying project performs poorly, becomes mismanaged, or collapses entirely, you face the very real possibility of losing your invested capital. And critically, a failed investment can directly jeopardize your entire immigration process. The job creation requirement. Of all the requirements within the EB-5 program, none carries more weight than job creation. This is the absolute cornerstone upon which the entire immigration benefit is built. For an investor to qualify for a green card under EB-5 regulations, the investment must directly or indirectly generate a minimum of 10 full-time jobs for qualifying United States workers. This requirement is non-negotiable and cannot be waived under any circumstance. Full-time employment is defined as a minimum of 35 hours worked per week. The jobs must be filled by United States citizens, lawful permanent residents, or other authorized workers, not by the investor or the investor's immediate family members. If the 10-job threshold is not demonstrably met by the time you apply to remove the conditions on your green card, permanent residency will be denied regardless of the capital invested. Direct investment route. There are two primary investment routes available under the EB-5 program, and each carries a fundamentally different profile of control, complexity, and risk. The first is direct investment. Under this route, the investor establishes or acquires a direct ownership stake in a new commercial enterprise and assumes personal responsibility for its management and operational direction. The investor must also take an active role in ensuring that the business generates the required minimum of 10 full-time jobs. Direct investment offers a significantly higher degree of control over how capital is deployed and how the business is managed. However, this control comes at a substantial cost. The investor bears full operational responsibility, must navigate complex compliance requirements, and assumes the entirety of the business risk. This route is generally more appropriate for experienced entrepreneurs with a clearly defined business strategy already in place. Regional Center Route. The second and considerably more popular route under the EB-5 program is investment through a government-approved regional center. A regional center is an organization that has received formal authorization from United States Citizenship and Immigration Services to pool capital from multiple investors and deploy it into large-scale commercial projects. Common examples include real estate developments, hospitality projects, infrastructure initiatives, and mixed-use urban development. The regional center model is classified as passive investment. The investor contributes the required capital, and the regional center assumes full responsibility for managing the project, overseeing operations, and demonstrating compliance with job creation requirements. Because job creation under the regional center model can be calculated using broader economic methodologies, meeting the 10-job requirement is generally more achievable. However, the passive nature of this arrangement means the investor relinquishes direct control over how their capital is managed. The application process. Step 1. Now that the foundational elements of the EB-5 program have been established, it is important to walk through the application process in a structured and sequential manner. The first stage involves selecting a qualifying investment project and committing the required capital, either $800,000 or $1,050,000, depending on the investment location. This decision should never be made hastily. Thorough due diligence on the project, the managing organization, the financial structure, and the track record of those involved is absolutely essential before any capital is transferred. Once the investment has been made and properly documented, the investor files Form I-526E, the Immigrant Petition for Alien Investors, with United States Citizenship and Immigration Services. This petition formally initiates the immigration process and demonstrates that the investment meets all regulatory requirements. The application process. Step 2. Following the approval of the initial immigration petition, the application process moves into its second critical phase. If the investor is residing outside of the United States at the time of approval, they will proceed through consular processing at a United States embassy or consulate in their home country. If the investor is already lawfully present within the United States, they may file for adjustment of status domestically. Upon successful completion of this stage, the investor and their qualifying family members, including a spouse and unmarried children under the age of 21, receive conditional permanent resident status. This conditional green card is valid for a period of 2 years. During this 2-year window, United States Citizenship and Immigration Services monitors the investment to verify that it remains deployed, that the commercial enterprise is operating, and that the job creation requirements are progressing as required. Removing conditions and receiving permanent residency. The final and most consequential stage of the EB-5 process is the removal of conditions on the investor's green card. Within the 90-day window preceding the expiration of the 2-year conditional green card, the investor must file Form I-829, the petition to remove conditions on permanent resident status. This filing must provide comprehensive documented evidence that the investment capital was fully deployed and maintained throughout the required period, that the commercial enterprise has been actively operating, and most critically, that the investment has created or can reasonably be expected to create a minimum of 10 qualifying full-time jobs. If the evidence submitted is thorough and all conditions are verified as satisfied, United States Citizenship and Immigration Services approves the petition. The investor and their family members then receive unconditional permanent green cards with no further conditions attached. Processing timeline and visa backlogs. One of the most significant practical realities of the EB-5 program, and one that genuinely surprises many applicants, is the processing timeline. This is not a rapid immigration pathway. Even under favorable conditions in 2026, the end-to-end process from initial investment to receiving an unconditional permanent green card can span multiple years. For investors from certain countries of birth, particularly China, India, and Vietnam, the situation is considerably more complex. These countries face substantial visa backlogs as a result of per-country annual caps imposed by United States immigration law. In practical terms, this means that even after an investor's petition is fully approved, they may face an extended waiting period of several additional years before a visa number becomes available. Any investor considering the EB-5 program must account for this reality explicitly in their long-term planning and personal timeline expectations. Risk. 1. Project failure. The EB-5 program carries 3 categories of risk that every prospective investor must understand clearly before committing capital. The first and most financially consequential is project risk. Not all EB-5 investment projects are created equal. The market includes well-structured, financially sound projects managed by experienced development teams with strong track records of delivery and compliance. However, it also includes projects that are poorly underwritten, overly optimistic in their financial projections, or mismanaged by operators with insufficient expertise. When a project underperforms or fails entirely, the consequences for the investor are severe on 2 levels simultaneously. First, the invested capital, which carries no guarantee of return, may be partially or entirely lost. Second, and equally critical, the failure of the underlying project to generate the required jobs can result in the denial or revocation of the investor's immigration benefits. Risk 2. Fraud and misuse of funds. The second major risk category within the EB-5 program is fraud. While the program is federally regulated and subject to Securities and Exchange Commission oversight, documented cases of investor fraud and misappropriation of funds have occurred throughout its history. In several high-profile enforcement actions, investors were provided with materially misleading information about project viability, financial structure, and the intended use of investor capital. Funds were in some cases diverted by operators for purposes entirely unrelated to the approved investment project. For foreign investors who are not physically present in the United States and who may be unfamiliar with the domestic legal and regulatory landscape, identifying fraudulent schemes can be exceptionally difficult. This reality makes comprehensive due diligence and engagement with reputable, independently verified legal and financial professionals not merely advisable, but absolutely essential prior to committing any capital. Risk 3. Processing delays. The third risk category is processing delays, and it is one that even well-prepared investors with fully compliant projects frequently encounter. United States Citizenship and Immigration Services processing times for EB-5 petitions are subject to significant variability and are influenced by multiple factors, including application volume, staffing levels, regulatory changes, and administrative priorities. Delays can occur at multiple stages: during the initial petition review, during consular processing, and during the conditions removal phase. Beyond internal processing timelines, investors from high-demand countries face additional waiting periods imposed by visa backlog queues that operate entirely independently of petition processing. For an investor who requires United States residency within a defined time frame, perhaps due to business obligations, educational plans for children, or personal life circumstances, these unpredictable delays can represent a serious strategic and personal challenge. Who should consider EB-5? With a thorough understanding of both the process and the risks now established, the practical question becomes, for whom is the EB-5 program genuinely appropriate? The ideal EB-5 candidate is a high-net-worth individual or family who possesses the required investable capital, is not dependent on a specific short-term immigration timeline, and is seeking permanent United States residency without the constraints of employer sponsorship or occupational category requirements. The program is particularly well suited for investors who wish to relocate with their entire immediate family, as a spouse and children under 21 are included in the green card benefit. It is also appropriate for business owners and entrepreneurs who prefer an immigration pathway that does not require them to be tied to a specific employer. The key qualification is genuine financial capacity combined with a long-term strategic perspective on both the investment and the immigration goals. Who should not consider EB-5? Equally important as identifying who the EB-5 program is suited for is understanding clearly who it is not suited for. If you are seeking a rapid immigration solution, the EB-5 program is not the appropriate pathway. The multi-year timeline, compounded by potential processing delays and visa backlog queues for certain countries of birth, makes it incompatible with urgent relocation requirements. If you expect a guaranteed financial return on your invested capital, this program is also not appropriate. The at-risk requirement is a fundamental regulatory condition, and capital protection is never assured. If you are unwilling to engage thoroughly with legal due diligence, financial analysis, and ongoing compliance monitoring, you are not prepared for this process. And if your investable capital falls below the minimum threshold, there are no provisions for partial investment or installment arrangements under the current regulatory framework. Family benefits. One of the most compelling and frequently cited advantages of the EB-5 program is its inclusive family benefit structure. Unlike many other United States immigration categories, which require each family member to independently qualify or meet specific eligibility criteria, the EB-5 program extends its benefits broadly to the investor's immediate family unit. A qualifying investor's spouse is eligible to receive conditional and subsequently permanent resident status as a derivative beneficiary without any separate investment or qualification requirement. Unmarried children under the age of 21 are similarly included in the application as derivative beneficiaries. This means that with a single qualifying investment, an entire family can obtain United States permanent residency simultaneously. For families with children approaching or currently enrolled in university-level education, this benefit can carry substantial practical and financial value given the significant tuition differential between domestic and international student rates at American institutions. Legal guidance and due diligence. Given the financial complexity, regulatory specificity, and high-stakes nature of the EB-5 program, professional legal and financial guidance is not optional. It is a fundamental requirement for responsible participation. An experienced immigration attorney specializing in EB-5 will guide you through petition preparation, document compilation, and compliance monitoring at every stage of the process. Equally important is independent financial due diligence on the specific investment project you are considering. This includes a thorough review of the project's business plan, financial projections, the operator's development track record, the escrow and fund release structure, and the methodology used to calculate job creation. Engaging a securities attorney to review the offering documents is also strongly advisable. Investors who bypass this level of scrutiny in the interest of speed or cost savings disproportionately represent those who ultimately lose capital, face immigration complications, or both. EB-5 in 2026, current landscape. The EB-5 program has undergone significant legislative and regulatory evolution over the past several years, most notably through the EB-5 Reform and Integrity Act of 2022, which introduced substantial changes to program administration, regional center oversight, and investor protections. As of 2026, these reforms have strengthened the regulatory framework governing regional centers, introduced new integrity measures to reduce fraud risk, and created reserved visa categories for rural and high unemployment area investments. These reserved categories can offer meaningfully shorter processing timelines for qualifying investors. However, the overall demand for EB-5 visas continues to significantly exceed annual supply, and investors from high-demand countries continue to navigate extended backlog periods. Understanding the current regulatory environment, available visa categories, and country-specific backlog projections is essential for making an informed decision about whether to proceed in the current landscape. Final verdict and call to action. The EB-5 investor visa is a legitimate, federally regulated, and genuinely powerful pathway to United States permanent residency. For the right investor, one with sufficient capital, a long-term perspective, professional guidance, and a clear-eyed understanding of the risks involved, it represents a viable and structurally sound immigration strategy. However, it is unequivocally not a shortcut. It is not a guaranteed outcome. And it is not appropriate for every individual regardless of financial capacity. It is an investment first and an immigration program second, and it must be approached with the same rigor, discipline, and professional support that any major financial and life decision demands. If you are seriously evaluating the EB-5 program, begin by consulting a qualified immigration attorney, conducting independent project due diligence, and ensuring your personal and financial timelines are genuinely aligned with what this process realistically requires.